right. Well, to all the attendees, many thanks for joining us this morning. We're very much happy to have you here. My name is Chris Curtis, and I'm here right now presenting with my colleague and Talita, and we're both co-heads of the Trust and Estates Department here at Chaves Perlowitz Luftig. We deal both in the domestic area of estate planning as well as the international area of estate planning. I tend to handle more the domestic side of things, and Talita tends to handle more of the international side of things. So in this presentation, I'm going to be pretty much taking the lead here because this really just comes up with the domestic issues. With domestic clients, excuse me. So, you know, anyone has any international questions, feel free to ask them to Talita. Let's get started then. So this is estate planning for blended families and second marriages. So, all right. So, you know, the first thing that it would be good to do is just to sort of get an idea, what are we talking about exactly here, right? And some of it's common sense, but let's just, so, you know, what do we at least consider a blended family when we're talking for estate planning purposes? We're looking at married couples, you know, where one or both spouses has a child or children from a previous marriage, families who have children in a second or subsequent marriage with children from a previous marriage. And then you also have not only that, but one is a little bit overlooked. And this is more on the side of asset protection planning, is families with children whose spouses have children from a previous marriage. So, or their children are in a second marriage, for instance, right? And they have children from a first marriage. So, those are key considerations when we're considering providing an inheritance or gifts to children, right, and to protect them from a second spouse and that second spouse's family. All right, so another thing that's important to touch on just briefly is the effects of divorce on spousal rights. And a lot of these topics, these slides, you could do whole presentations on. So I try to keep them here as simple as possible, at least just for purposes of this discussion. But so what are the basic effects of a divorce on spousal rights? So the first thing that's very key here is the ex-spouse ceases to have any spousal right over the election, right of election over another spouse's estate. That's essentially like a forced heirship right that exists under common law and here in New York, as well as virtually every other jurisdiction in the United States. If you don't know what that is, then don't worry. We're going to have another slide that explains that in a little bit more detail. If the last will and testament, and I'm just going to refer that to WLT in the slide, is not updated following the divorce, the ex-spouse is considered as having predeceased and does not take under the terms of the last will and testament. Rights of a former spouse to act as a fiduciary, for instance, like in a trust, executor, trustee, guardian, or power of attorney, are all automatically revoked. So you don't actually have to go into your estate plan and take them out as executor, take them out as guardian, trustee, or take them out as your power of attorney. It's all deemed revoked, right? The state law assumes that's what you wanted. Finally, this really applies to real estate, is that a tenancy by the entirety is automatically changed to a tenancy in common. So those that you aren't familiar with a tenancy by the entirety, that's basically jointly held property, but it's specific and it's exclusive to married couples. Only married couples can have tenancy by the entirety. And basically what that means is so there's a presumption that if you title real estate in the names of two spouses, husband and wife, then that creates a tenancy by the entirety. Basically that means is that the other spouse, upon the death of one spouse, the other spouse automatically inherits 100% of the real estate, regardless of what's said in any sort of last will and testament or trust or whatever, any other document outside of that deed. The deed is what controls. And so when the divorce occurs, this is then changed to a tenancy in common. So tenancy in common, there is no automatic right of survivorship. What happens is a tenancy in common means a spouse passes away. There's two spouses. Let's assume they're still on the deed. That's usually not the case for divorces. Usually it's already figured out at the conclusion of divorce who gets to keep the house and the rights of each spouse. But sometimes, you know, a spouse can pass away during the divorce proceeding. But then let's say, for instance, after the divorce, both spouses' names are still in the property, but it was never changed from tenancy by the entirety, goes to tenancy in common. That means each spouse has their own interest, separate interest, that then gets passed on to their estate, essentially like a 50-50 split. And then when that one spouse passes away, then their portion then goes per their estate plan, either by intestacy rules, if they don't have a will, or by will by the terms of their will. So I had touched upon this briefly just before about spousal right of election. So yeah, spousal election, second spouse can never be completely disinherited. New York is very similar to a lot of states. They have these forced rules of heirship for spouses. They don't like spouses being completely left out of an estate plan. So this, when you're talking about blended families and second marriages, you sometimes have clients say, well, you know, I'm in a second marriage, but I really want to just leave everything to my kids from my first marriage. You can't do that, at least not without extensive planning beforehand. So yeah, you have to take planning spouse's right of election. And so let's say, for instance, that you do have a spouse that decides to have kids from a previous marriage, and they decide, I'm just going to disinherit my second spouse and just leave everything for my kids. Spouse can then elect against that deceased spouse's estate plan in surrogate's court. Surviving spouse in New York is entitled to take the larger of the $50,000, right? So if the estate is worth up to $50,000, then they take the entire estate, or 1/3 of the deceased spouse in that estate. And you might notice here, I'm just putting some comparative things, just so there's a lot of snowbirds that have a property interest in Florida. So I do a few comparisons to Florida, and here Florida elective share only allows 30% to the surviving spouse, a little different. I'll touch on Florida Homestead rules as well and primary residences later on. Deceased spouse's estate for spousal election purposes is very, very broad. It's what's called the augmented estate. So if the decedent spouse is just thinking that, you know what, I'm just going to gift everything during life, I'm going to put everything in a trust, I'm going to put in trust for designations, beneficiary designations on bank accounts, well, that's not really going to work, because New York considers things that are typically considered what's called non-probate assets that get inherited outside of the spouse's estate to actually count for purposes of the spousal's right of election. So includes, you know, gifts made within 1 year prior to death, transfers to living trusts, accounts, beneficiary designations, etc. Notably, like I said, it does not include gifts made over 1 year before death. So that actually can provide some planning opportunities, which we'll touch on a little bit later, because if you plan way ahead of time, then those can, if you make gifts, for instance, to a trust way ahead of time, but in certain trusts that have to be irrevocable, for instance, then you can actually avoid the spouse right of election, at least on those assets. It also does not include life insurance proceeds, where a beneficiary is anyone other than the estate. So, for instance, you could buy life insurance, a $1 million life insurance policy, right? And you can just have your kids listed as beneficiaries. So then the kids will take that money. The spouse would have no right of election over that money. Lastly, an important thing to mention is that the spouse's right of election is not something completely absolute. I mean, there are ways in which you can eliminate that. And the most common one is doing a pre and post-nup agreement to eliminate that right of election. I actually do this for clients. We assist them with typically prenups. Obviously, those are more easier than post-nups. Prenups are always the better way to do it, but you can do it after marriage. It's called a post-nup, where the spouses basically can agree, like, you know, I waive my right of election. And then with that waiver of the right of election, the spouses are essentially free to determine their own estate plan, and then they can very much disinherit the other spouse. So I think I apologize. I think I've got 2 slides that are pretty much the same. So let me just skip that one. So another thing that's important to mention about spousal right of election is that a spousal right of election could also include an interest in a family or closely held business, right? So this can be very important when you're dealing with second marriages and kids from the first marriage. Maybe those kids from the first marriage don't get along very well with the second spouse, right? And this wouldn't be ideal if you're looking for your children to inherit the business, the family business, right? Because depending on the value of the estate and what's included and not included in the spousal right of election, the spouse could potentially demand that she receives some or all a portion of a business interest, right? Like an interest in a partnership, an interest in a membership in a LLC, shares in a corporation, and that can really screw things up because then we have to look at a review of the bylaws, operating agreement, partnership agreement is fundamental to determine the rights, because then what could happen is most of these agreements actually don't allow a surviving spouse to really step in as a partner, for instance, right? They sort of usually give the surviving shareholders a right to purchase, a right of first refusal, essentially. But then that can create issues with the business, right? Maybe the surviving partners don't have the funds to purchase it, or maybe maybe the decedent was the only shareholder, right? And so there's going to be a forced sale of the business. So it's always important to keep these things in mind. Now, some things that we could potentially do in terms of planning for that would be, for instance, putting in some sort of irrevocable trust. I'll touch upon it later, well in advance with whatever child you want, child or children, to inherit to be the beneficiaries of that trust. But again, that kind of planning is required to be done way in advance. And another thing, I apologize, I think there seems to be a mix-up here with the slide. So I did do some effects of divorce continued. This was meant to be before. Two things it would be important to touch upon here with the effects of divorce is that there was no automatic revocation designation of in-laws, right? So where there was an automatic revocation of the spouse as an executor, guardian, beneficiaries, that's not the case for in-laws. So if you don't want your ex-spouse's parents, right, to be executors, guardians, beneficiaries of any sort of trust, then it's important to keep that update. It also can create, the divorce as well can also create potential gaps in an estate plan if a divorced spouse was nominated as executor or beneficiary, because then who's going to actually step into that place, right? Or even as a trustee of a trust, for instance. So it's important to keep those things in mind.
Also, Chris, I think something that's important to mention in terms of the revocation, because we talk about the tenants in common, the tenants by its entirety. I think that, for example, whenever there is like a life insurance, it's not revoked, and that's why it's very important for you to review once you're having a second marriage, because if the name of your first spouse is in this life insurance, she's going to inherit all of the proceedings.
Or even worse, actually, I had a case, and this was actually years ago in law school, but I had a case where there was quite a substantial, I think it was like a retirement account, and the decedent was in a second marriage. He had divorced his first spouse and he had kids, and nobody got along. And in the beneficiary designation, he said, "I leave it all to my wife." and when he wrote that, he was in his first marriage. So was it the first wife or the second wife? And we didn't know. I wasn't part of that case to really see what the conclusion was. But yeah, for certain, you want to keep everything updated. Just to avoid those kind of issues and complications, right? Don't just assume that the law is going to take care of everything, right?
Sometimes the law can assume, though, but in this specific case, it is not going to. So
right. So let's just touch on real fast here, rights of children to inherit, right? So a lot of countries in the world actually have forced heirship rules, right? That essentially require the decedent to leave something not only to a spouse but also children. Common law countries like the United States, we're very unique in that the only person that has any right is the spouse. Like children actually have no right of inheritance whatsoever. An individual is free to disinherit their children. So yeah, divorce is.
Can I add to that?
Sure.
Yes, I come from Brazil, and it's a civil law country, and we do have forced heirship, and you have to respect the limits of the distribution of your assets. And here in New York, for example, yeah, you have a huge flexibility, except for the spouses election that you have to respect. But as here it says, you can disinherit completely your child. Or in some things that I think always you have to be in mind whenever considering a second marriage is that, for example, in a first marriage, you have children who is already 40 years old, successful, owner of a business. And then in the second marriage, you have a child of 10 years old who has a life ahead, that has to study, that has a lot to live and will probably need much more support.
Right.
So here you have this flexibility of changing the distribution. You can definitely give more to a child that has more needs than the other one. So I think that this is amazing, and that should be definitely considered when you're thinking about your estate planning.
Right. Of course, you always have to keep in mind if you're doing cross-border planning, is looking at both sides of the equation while assets are on each side. If a judge can't get assets here in New York, for instance, then they can certainly go and try to get more assets in the home country. So that's always important. Yeah. So rights of children to inherit. So divorce has no effect on the rights of children of the marriage, right? So there's no sort of automatic kill off of the kids for purposes of estate planning like there is the spouse. They're not automatically disinherited. And as we just mentioned, they can be completely disinherited. Then one important point, though, to note is with second marriages, and this typically happens when there's a second marriage and a spouse has kids from a first marriage, but they're estranged from those kids for whatever reason, but they're very, very close to the children of the second marriage, almost like their own children. It's important to know that if the child is not a biological child or legally adopted by a parent, and then that parent does not include them in the will, then intestacy rules in New York control, which is basically the state taking a guess at what you would have wanted, and that child from that's not biologically or legally adopted by that parent, they'll receive nothing under intestacy laws of New York. And whereas you might have a child from a previous marriage of who's estranged, and they could potentially get everything. So that's another important consideration to have estate plan in mind for blended marriages. So I figured I'll just give you guys a really quick example here of an issue that I've come up with that is a fairly frequent issue. It involves real estate and a blended family. So let's just get into it. So Henry is married to Wendy. This is the second marriage for both of them. Henry has a son named Sam from his first marriage, with whom he is estranged and hasn't had contact with in many years. Wendy has a daughter from her previous marriage named Daniela, with whom Henry is very close. Henry has never legally adopted Daniela. Henry and Wendy's primary residence is located in Nassau County, New York. The residence is only in Henry's name. Henry does not have a last will and testament. What happens then in this situation if Henry were to pass away? So the surviving spouse from the second marriage could, hang on a second, I think we're having some issues here. Examples of, apologies guys, sorry. Okay, I apologize for that. It seems some of the slide. So the example continued. The intestacy rules of New York essentially would apply for Henry's estate, so that the state is going to step in and use their rules to guess what Henrietta wanted. So in that case, Wendy, as Henry's spouse, would inherit the first 50K of the estate plus half the balance, right? So if the estate is only worth 50K, then Wendy inherits it all. If it's worth more than 50K, she gets half of whatever's left. Now, the real issue here is who gets that remaining half balance, and that wouldn't be Daniela, who's Henry's favorite. It's actually Henry's estranged son Sam who would inherit the remaining half balance, right? And Daniela would inherit nothing, as she's not considered to be Henry's legal child. Now, what's the issue with that half balance is that half balance could even include the marital residence, right, of the second wife, and Daniela could even be living there. And Henry's estranged son could actually potentially force a sale. Wendy might be forced to either buy out Sam's interest in whatever he might have in the house, or she might be forced to sell it in order to satisfy that. And that's all to an estranged son who Henry probably hasn't had any contact with for years. Obviously, and then of course it could create emotional issues, right? Because then they're going to be fighting constantly, and then poor Daniela and Wendy might be forced out of the house, and probably that they've lived in for many years. So I just thought I'll put another comparison here, actually, because I do Florida estate planning too. I'm licensed in both New York and Florida. So it's worth noting how different it can be depending on the state. And Florida is a notable example. You know, Florida has these homestead rules, and most people know the Florida homestead rules because they actually provide a great amount of creditor protection. You can essentially have a house worth $10 million, but if it's your homestead in Florida, your creditor can't touch it. Some of you probably would remember O.J. Simpson case after he lost that civil case suit against him by Goldman's parents. What happened was he then essentially packed up, went to Florida, purchased a huge mansion there, and the Goldmans could touch it because of the Florida homestead rules, his primary residence. But Florida homestead rules aren't only good for creditor protection; they also provide protection for spouses and minor children in the event of the death of the homeowner. So this would actually have a very different outcome in Florida if Henry and Wendy had lived in Florida. Florida homestead. So what is property is real property owned by the decedent. The decedent was a Florida resident, and the property was the residence of the decedent or his family. That's it. Those are the rules. If it's their primary property, he was a resident of Florida, it's homestead. You don't have to make any sort of registration of the homestead. It's just based on the facts of the case. And the homestead may not be devised if the owner is survived by a spouse or minor child. If only survived by a spouse, then the homestead property may be devised only to the owner's spouse. So essentially, Florida here has some forced heirship rules, right? Because at least when it comes to a primary residence. So let's get into some estate planning strategies. We've been discussing all these problems and stuff. So, what can you do to avoid them? Well, perhaps the easiest way to avoid these strategies is, first of all, for the spouses to have a discussion. This in the second marriage I'm talking about, and ideally, in an ideal world, it would be to have a prenup agreement, right, to waive the spousal election. So both spouses can decide how they want to leave property. And that's not an entirely unreasonable conversation. If you have kids from a first marriage, then you're going to want to leave them specific assets. So maybe you don't want to have a discussion with your second potential future spouse to just waive their entire right of election, but you could have a discussion with them as to, what, I have a family business, or I have this, I really want to leave it to my kids. So let's put it in a pre or post nup, a prenup agreement that only my kids from my last marriage get this. That's a much easier conversation to have before the marriage than after the marriage, right? Because after the marriage, they already have rights, and the only way you're going to take away that right is either a post nup or getting divorced, essentially. One thing that you can use, now some of these that I'm going to talk about is you're going to need some sort of spousal agreement, right? You're going to have to be on the same page with the spouse. For instance, you can have a life estate, right? So you have a deed to your house, and then you title that deed as a life estate in your spouse, and then the remainder to your children from a previous marriage. That can that could work if your spouse is in agreement with that, right? But if your spouse is not in agreement with that, they can change their mind after death, unless there's a pre or post-nup agreement in place. Then they could still elect have a spousal right of election against that life estate, because New York only really considers valid if it's an outright gift to the spouse. It can't just be like for life or things like that. Trust is the most common planning tool in these situations. It can provide, flexibility for the spouse during lifetime, to children after a fallen, during or the surviving spouse's life, or after the surviving spouse's death. Irrevocable life insurance trusts, that just touches back on the fact that the children have a right to any insurance proceeds outside of a spousal right of election. So they could be discretionary beneficiaries of an ILIT. Now, it doesn't actually have to be an irrevocable trust. We would suggest that for asset protection purposes, just to protect the children. Then their creditors can get to it, but you can just have them as the outright beneficiaries of the life insurance policies. Also another benefit with trusts is you have what's called dynasty trusts. You can have added benefit provided for multiple generations. And as I just touched upon right now, to allow for what's called spendthrift clauses. That's what protects against creditor claims for your children, for your future spouse. And trust can also be a very handy tool if your second spouse that's deceased isn't very financially savvy. You're the one that controls all the bills and all the investments, and maybe they're not very good at money. You can put things into a trust. But again, this should all be done planned way ahead of time. And these planning tools specifically are more to do with revocable trusts, right? So revocable trust is a very common estate planning tool, but for purposes of defeating the spousal election, it's not valid because you still had control of that during your death. So right here on the second page, these are some potential gifting strategies, because if you might recall, any gifts made more than 1 year after death, they're not included in the spousal right of election calculation, right? So some potential gifting strategies can actually go hand in hand with the more complex tax planning strategies. Tax planning strategies, which you typically only utilize to try to reduce or eliminate the estate tax, could actually work in this case. For instance, you might consider what's known as a Q-tip, right? So, which is basically an irrevocable trust where the surviving spouse has the right to income during his or her life, and then remainder can be to the children of the first marriage. So if you do that with enough planning, then that could potentially work. The problem, Q-tips is an interesting one, actually. Up until about most states actually allow you to put the funds into a Q-tip trust. And not only for federal tax purposes, but also for purposes of the spousal election, they consider it acceptable that the spouse doesn't inherit it outright. They only have a right to income during their life. New York was the same way up until about 30 years ago, up until 1994. And then they decided, no, the spouse has a right to receive it completely. So Q-tips aren't as effective as they were in New York. As I mentioned previously, irrevocable life insurance trust, this is something that's done for tax planning strategies to keep significant insurance proceeds out of someone's estate for U.S. estate tax purposes. It can also work here, as previously mentioned, because it would be outside of the spousal right of election. A sale of appreciable assets to an intentionally defective grant or trust. So that could work. This particular one can work very well with business interests, right? Because the spousal right of election really only touches on gifts or any transfer for less than fair market value, right? So if you actually sell it, then that won't be included. Of course, a promissory note would be included in your estate, but if you're selling, for instance, shares in a family business, then what's really important is those shares are put into a trust where a favorite child who stands to inherit the business is actually the beneficiary and controls it. And last of all, planning must be done well in advance. So some final thoughts here. Plan ahead of time. That's probably the, if anything, for any estate plan, but especially with second marriages and kids, you really do need to plan ahead of time, because some of these planning strategies won't be effective if you're planning right in the last minute on your deathbed. It's at least the gifting ones just aren't going to work. As I've mentioned before, ideally plan before marriage. Prenup, either eliminating or reducing the spousal right of election, is really the best way to do it. Now, prenups and postnups have to be taken very seriously. There's some strict requirements for those to be considered valid. So, but once those are in place, then it gives each spouse significant freedom to make their estate plan without having to worry about the potential for that spouse to go for that spousal election. And at the very least, have a last will and testament in place, because the last thing you want is that example that we had with Wendy and her husband, right, that passed, Wendy and Henry, who Henry passed away, and then intestacy rules allowed for his estranged son from the previous marriage to potentially get the house. If Henry had at the very least, the last will and testament in place, giving everything to either his spouse or to his spouse and his stepdaughter Daniela, then that would have avoided the entire situation. So at the very least, the last will and testament is key here, because intestacy rules, especially blended families and second rules, rarely gets it right. Okay, the state is usually not right on that. Obligatory disclaimer: information here does not constitute legal advice, is informational purposes only. I'm not your attorney, at least not right now. Please seek legal counsel in relevant jurisdictions, and this doesn't create any sort of attorney-client relationship. This is as is, things can change, all that kind of good stuff. And thanks for listening. So if you guys have any questions right now, we're free to try to answer them for you. If you think of a question after the presentation, by the way, our emails are here. Oliver's going to send you a copy of this presentation, and you can feel free to reach us out to email if you think of a question as well. So let's just see here. So Stuart says, what about rights of afterborn children? That's a good question, actually, because so afterborn children, right? If you have your last will and testament, if you hang on, okay, sorry, that was Smith. So yeah, afterborn children actually do have rights as well. There is a presumption in the law. There is a presumption in the law that if you have afterborn children, for instance, you have something in a document that says that a group of children, typically they leave it to their children, right, in equal shares, for instance. But if you only name 2 kids, then you have 1 kid that's born afterwards, there is a presumption in the law that you wanted to have left something for that child, unless the document expressly provides otherwise. So yes, afterborn children do, depending on the circumstance, depending on the document, they actually do have some rights under the law. Chat, so I got 4 here. Let me just
Chris, the best way then to avoid any potential doubts is just to include the class, right? Instead of I leave to my children equally. So instead of naming the children.
Okay. Yeah. Kathy has a question here. Can you discuss current taxation on estates and how is that changing over the next few years? Yeah, sure, Kathy, no problem. I can answer that. It's a little off topic here, but very basically then, because there's all sorts of different tax issues coming up now with estate planning. The key one here is estate tax, right? Once you pass away, is there going to be any estate tax? Current federal level is 11 million. So if your estate's under 11 million, you have no federal estate tax due. That's going to revert, sunset in January 2026 to half of that amount, around $6 million. In terms of New York has an estate tax as well. That's currently around $6 million right now, the exemption, with a cliff, by the way. So if you have more than 105% over that, your whole estate's taxed. I don't predict anything for U.S. estate taxes to change. Biden hasn't made any proposals on it, and I believe that's just because there's a sunset clause in there, so they're not going to waste political capital on that. However, I actually did a webinar on this a couple of weeks ago, and if you like, reach out and we can send you a copy of the presentation. But there are two notable proposals that Biden made. One is capital gains increase, but also if there's capital gains built into the estate in excess of, I believe, $1 million, then there's actually going to be a deemed sale of those, and then the estate's going to have to pay tax on that, even if they don't sell the estate. That's the most radical proposal. He's also considering eliminating the step up in basis, which is more to income tax, right? So a step up in basis, that you get fair market value for the new basis upon death of someone transferring. He wants to eliminate that, so then the heirs will essentially inherit the basis, which will create an income tax liability for the heirs, which currently don't exist. So hopefully I was able to give you a very broad explanation of that. Biden's proposals are just proposals. They're not going to affect until there's congressional approval. I'll keep everyone updated as much as possible on that. So there hasn't been much movement on it so far. See anything else? And I don't see anything else. I'll just give it one more minute, and then after that, I guess we can and again, if you need to, just feel free to reach out. Again, apologies for the mix-up on some of the slides. That's my fault. I actually, about 15 minutes before, I thought of a few last-minute things I wanted to add to the presentation, so I started adding slides like crazy. So you're all going to get a copy of these slides, by the way, anyone that signed up for this. But I'm going to go ahead and fix these before Oliver sends this out to you guys. Thank you so much, Nancy. I appreciate it. Thank you. And another question from Kathy, also not exactly on topic, but since we are in real estate, does a revocable trust shield assets from creditors such that a co-op should be concerned when a purchase assets are in a revocable trust? Hi, Kathy. Yeah, simple answers to that. Revocable trusts do not shield against creditors. Revocable trusts are really just succession planning tools, right? They're just to facilitate transfer to your heirs, to your beneficiaries, right, to avoid a probate proceeding, and also to potentially shield against the creditors of future beneficiaries, right? But it doesn't protect against the settler, right? The person that actually transfers it to the trust if it's a revocable trust, because the settler has complete control over it. So creditors can always touch it. Now, you might have heard of irrevocable trusts, for instance, in Nevada, Wyoming, right? Those are what's called a self-settled trust. So it's an irrevocable trust where the settler is a beneficiary of that trust. And if it's structured correctly, it could protect against all creditors, including ex-spouses. It's a little untested, those laws, because they're relatively new. And it's questionable whether it would really help with real estate, because real estate is very local, right? So could you potentially take a house in New York, put it into a Nevada self-settled irrevocable trust? Potentially, but then you do have a New York court that could just disregard it, say it's against public policy of the state of New York, and then allow creditors to access it. Because what we have here in New York, is in pretty much any state, it's called the statute against fraudulent transfers, right? To try to get creditors reach, and there's strong public policies in those states regarding that law. So the best way in which to keep the hands away from a spouse is to potentially take out a mortgage on the, this is more of asset protection, but take out a mortgage on the property and potentially leverage it with low interest rates and a better rate of return. take that money, open up an account, a bank account in Nevada with a Nevada trustee, with a self-settled trust. And that way, yeah, you're not going to, a New York judge isn't going to be able to touch the bank account in Nevada. A local judge won't allow it, and they're going to respect Nevada law. And then all you're going to have left in New York is essentially a house with a liability of a mortgage, right? So yeah, that's just some asset protection strategies, and those can also go hand in hand with this kind of planning. But it's you can do asset protection. That's definitely an opportunity with the second marriages and things like that. But you know, you're always going to have your spouse in the picture, so the second spouse might not be too thrilled that you're taking out a mortgage on 90% of the value of the house, right? So and it could be difficult really to hide that from them. Thank you, Kathy. Thank you very much for the kudos. I appreciate that. And let me just check, make sure we don't have anything in chats. No. And so yeah, I think I think this is going to conclude the presentation. So thank you everyone for joining us. It was a pleasure. And any questions, feel free to reach out to us by email. Okay. Take care.
Thank you, everyone.